chain was on the ground when I got there. Not broken, cut. I stood at my gate and watched 8 strangers drive survey stakes into my soil. My land. Land my grandfather had cleared and planted before my father was born. That's when she stepped in front of me. Margaret Holloway, HOA board president. Clipboard in one hand, orange stamped document raised like a stop sign. Smile already in place like she'd rehearsed this.
This land is HOA property. You are trespassing, John. You are trespassing.
She said it loud enough for the crew to hear.
If you don't step aside now, I'm calling the sheriff to remove you.
I looked at the chain in the dirt. My father's lock. On that gate, for 30 years. Cut clean bolt cutters. No hesitation. Like someone who'd made a decision and slept fine afterward. I picked it up. They had no idea who they'd just handed that chain to. She held the orange document up like it ended the conversation. County stamped, filed, official looking. The transfer was finalized 3 weeks ago. You received notice. All further documentation will come through proper HOA channels. 2 board members stood a few feet behind her, arms crossed. The survey crew kept working. 8 men, an electric hammer, stakes going into my topsoil at regular intervals. Not one of them looked up. "Can I see the underlying deed you used for that transfer?" I asked. Karen's smile shifted the kind of shift that happens when someone realizes the other person isn't as confused as they'd expected. "That's a matter for your attorney to pursue through proper channels," she said. I reached into my jacket and pulled out my phone. "What are you doing?" She took a step forward. "Documenting. You are photographing HOA property without authorization." She said it firmly, like it was something that could get me in trouble. I kept shooting. The stakes in the ground. The tire tracks pressed into topsoil still soft from last week's rain tread pattern visible and clear. The cut chain in my left hand, the orange document she was still holding up. I got the board members' faces. I got the truck and its plates. I got the electric hammer, mid-swing, stake, mid-descent, into my earth. Karen turned and exchanged a look with the 2 men behind her. It wasn't panic. It was something smaller, a flicker of annoyance that I was still there, still calm, still photographing instead of arguing or leaving. I think she'd expected one or the other. I didn't give her either. My grandfather bought this land in 1948. The full parcel, 2,200 acres of working farmland, plus a quarter-mile strip of waterfront along the lake that nobody in the family had ever done much with. There was always something more pressing. The soil, the seasons, the equipment, the kind of debt that didn't announce itself. The waterfront strip sat quiet for decades, more boundary line than asset. In the late 80s, my father sold development rights on the upland portion to a residential developer. They built a subdivision 96 homes on the higher ground, an HOA to manage the common areas, a set of bylaws thin enough to mail in an envelope. For 20 years, the neighborhood and my farm occupied the same road in something close to peace. Different worlds, different calendars. Nobody needed to talk much. Then Margaret Holloway ran for board president 3 years ago on a community improvement platform. She won by 6 votes. I didn't pay much attention at the time. I should have. The first notices arrived within the year. $500 a week in commercial vehicle parking fines for trucks sitting near my barn. Formal complaints to the county about agricultural odor. A letter claiming my farmland fell under community jurisdiction and demanding HOA fee payments. I treated them the way you treat a strange noise the house makes at 2 a.m. You note it, you don't love it, but you don't call anyone yet. Until I found my father's lock in the dirt with a clean cut through the shackle. That afternoon I called Sarah Chen. She'd handled my grandfather's estate property law, 30 years of it, most of it in this county. I read her the exact wording from the orange-stamped HOA notice. I described the crew, the stakes, the direction the survey line had been running. She asked questions I hadn't expected. How close had the stakes come to the waterfront strip? Did the survey line run toward the lake? How far did it extend? I described what I remembered. Some of the stakes had extended toward the lake edge. I'd photographed them. I hadn't read much into the placement at the time. Sarah went quiet. Not the silence of someone organizing their thoughts. The silence of someone who had just noticed something in the shape of things, something that changed what everything around it meant. "Don't touch anything," she said finally. "Don't sign anything. Don't throw away that chain." A pause. "Pull everything from your grandfather's estate files. Deed, title, every page. I need to see the original property description." "What are you looking for?" I asked. "I need to pull your grandfather's original deed," she said. "There's something here you may not know about yet." To understand what Karen did, you need to understand what my father signed in 1987. It was a single document. 4 pages, standard county form, unremarkable language. A developer had approached the family about building a residential subdivision on the upland portion of the property, the higher ground, further from the lake, good for houses and dead for farming. My father didn't need that portion. He agreed to sell the development rights. But the developer also needed to cross the farmland to haul equipment during construction. So my father signed a temporary construction easement. The document was explicit. I've read it 100 times since. Paragraph 3. This easement is granted for construction purposes only and shall expire upon completion of the subdivision project. Temporary. For construction. Expires. That's it. That's the whole document. It was a hall pass, not a deed. The subdivision went up over the next 2 years. 96 homes on the upland. A homeowners association formed to manage the common areas. The developer platted the waterfront strip 18 lots along the lake edge as part of the community layout. Nobody at the time did a complete title chain search going back to the 1948 deed. The title insurance companies issued their policies and moved on. The homes sold. People moved in. Life went on for 30 years without a single serious problem. That was how it was when Margaret Holloway ran for board president. She won by 6 votes 3 years ago. The campaign was local enough that most homeowners didn't pay close attention. Community improvement, better amenities, stricter enforcement of standards. It sounded like the kind of platform you vote for without reading the footnotes. Within 12 months, I'd received 19 notices. Commercial vehicle parking violations, $500 a week. Every week, my farm trucks sat near the barn entrance on a county road that the HOA had nothing to do with. Agricultural odor complaints filed with the county, citing a provision in HOA bylaws that didn't apply to pre-existing agricultural operations. A formal written demand that I begin paying HOA dues because, according to Karen's interpretation, my farmland fell within community jurisdiction. I sent a response letter through my own attorney at the time. He was a generalist, good enough. The letter was polite and firm. The HOA went quiet for about 3 weeks, then resumed with a slightly different set of complaints. New notices, new dollar amounts, same intent. I started keeping files. Meanwhile, Karen's reach inside the community was doing something quieter and more effective than anything she'd tried with me. Inside 96 homes, a different kind of pressure was building. 34 households had received liens against their properties for disputed fines over 2 years, liens that could complicate refinancing, slow a sale, or simply sit there like a splinter. Most homeowners didn't fight them. Fighting meant board meetings, written appeals, the chance of additional violations being filed in retaliation. Most people calculated the math and wrote a check. The Pattersons didn't have that option. Howard and Ruth Patterson had lived in the community for 28 years. I'd known Howard since I was a teenager. He used to buy sweet corn directly from us in the summers. 2 years ago, they fell into a dispute with the board over $800 in fines contested, procedurally questionable, the kind of sum that shouldn't threaten anyone's home. Karen's board filed a lien, then escalated to a foreclosure warning. Howard was 71 years old. Ruth had a health issue that kept her from working. The threat became real enough that they consulted a foreclosure attorney. Over $800. I found this out later, not then. At the time, I was still treating my situation as a separate problem. What I didn't know, what Sarah told me only after she pulled the county records, was that while I was counting fine notices and writing response letters, Karen had been doing her own research. She'd hired a real estate attorney to search the county recording system going back to the original subdivision files. They found the 1,987 easement, and then either by deliberate plan or by a negligence that achieved the same result, they refiled it with the county recorder as a deed transfer instrument. The mislabeling turned a 4-page hall pass into what looked, on the county's digital records, like a permanent conveyance of 2,200 acres. A construction easement gives you the right to cross someone's land temporarily. It does not give you ownership. What Karen filed said otherwise, and the county recorder processed it without pulling the original document to verify the classification. That orange stamp notice she waved at me that morning? It was built on that filing. She had taken a document that expired the day the last house in the subdivision was completed, and used it to claim my family's land 35 years later. Sarah called it what it was. Fraud. She said it quietly, the way lawyers do when they want you to understand that a word is being used precisely, not dramatically. Fraud. I wrote that down in the margin of my notepad, circled it once. Then I opened a new folder and labeled it. Sarah spread the deed across her conference table like she was handling something fragile. 12 pages. Aged paper, slightly yellowed at the edges. The kind of document that had been folded and unfolded enough times to leave permanent creases. My grandfather's signature on the last page, in the kind of careful cursive that people used when they understood a signature was permanent. She read the legal description aloud. Metes and bounds, coordinates, reference markers from 1,948. The description covered the farmland, all 2,200 acres, and then continued past it. It didn't stop at the upland. It ran all the way down to the waterfront strip, the full quarter-mile along the lake. No exclusion clause, no severance notation, no line that said this portion is separate or this portion was conveyed elsewhere. One deed. Everything in it. The 1,987 easement is not a deed, Sarah said, setting the document down. It cannot function as one. What Karen filed with the county is a misclassification of a temporary instrument as a permanent conveyance. The transfer is legally invalid. She said it cleanly. The way you say something you've verified 3 times before, saying out loud. So I get the farmland back, I said. Yes. She paused. But there's something else I need to look at more carefully before I say anything definitive. She told me she needed another week with the title chain on the waterfront portion. I didn't push. Sarah didn't ask for extra time without a reason. While I was sitting in Sarah's office, Karen was standing at a podium. She'd called an emergency community meeting all 96 homeowners, the community center, folding chairs, a projector. One of her board members had apparently contacted a reporter from the local weekly. I found out about the meeting afterward, from Frank DeLuca, who attended and took notes the way he apparently did at every board meeting. Karen presented the farmland acquisition as a victory. She showed renderings a recreation park, a trail system, picnic areas with trees that hadn't been planted yet. She explained that the HOA had secured the land through a recorded county instrument, that it represented a major enhancement of community value, that every homeowner should be proud of what the board had accomplished. A board member named Vic stood up at one point and called her visionary. She accepted the compliment without much visible effort. Frank told me that not one homeowner raised a hand to ask how a homeowners association had acquired 2,200 acres of someone else's private farmland. Not one question about the mechanism, the cost, the legal authority, the vote. 34 of those homeowners had active liens against their properties from Karen's board. The math on asking questions had already been calculated by most of the room. The applause at the end of her presentation was, by Frank's account, polite and nervous. The kind of applause that keeps the peace. The notice arrived 4 days later. 30 days. Remove all farm equipment from HOA-administered land, or the board would contract a towing and impound company to clear it. Estimated fees for towing and storage, $18,000. Payable by me. The letter cited the transfer filing as legal authority and included a certified copy of the orange-stamped county document. $18,000. For equipment sitting on land my grandfather had bought outright 75 years earlier. I photographed the letter, added it to the file, and kept working. The gas station was 4 miles from the farm. I stopped there on a Tuesday afternoon to fill the truck. Karen pulled in 2 minutes later. Not a coincidence, her vehicle came in from the direction of the community, not the highway, which meant she'd seen my truck and followed. She had 2 board members with her. She walked over while the pump was still running and leaned against the side of my truck like she owned that too. I want to be straightforward with you, she said. Her voice had the specific quality of someone who had prepared the next sentence in advance. We're going to develop that land with or without your cooperation. You can make this easy, or you can make this expensive. That's your choice. She was smiling. Both board members were smiling. It was the smile of people who believe the other party has already lost and just hasn't admitted it yet. I looked at her for a moment. I appreciate you being clear about your position, I said. I hung up the pump, got in the truck, and drove back to the farm. I heard later from a woman who'd been filling her car 2 pumps over that Karen watched me pull out, said something to the board members, and laughed. That week, I pulled every HOA notice I'd received going back 18 months and organized them by date, type, and dollar amount. I requested official certified copies from the county recorder of every document Karen's team had filed since she took office. I photographed every remaining survey stake still standing on the property, logging GPS coordinates for each one and noting the direction the survey line ran. I built a folder that was beginning to look less like a complaint file and more like a case file. I was calm about it. I want to be clear about that. I wasn't calm the way people are calm when they're holding something down. I was calm the way you get when you understand that the next move isn't an argument, it's a document. That evening, Sarah called. She spoke slowly, measuring her words. The waterfront stripped those 18 lots where the board members built their mansions. A pause. I don't think the developer ever had clean title to them. Another pause, shorter. And if that's true, I don't think the people living in those houses do either. I sat with that for a long time after she hung up. I didn't go looking for them. They came to me. Frank DeLuca knocked on my farmhouse door on a Wednesday morning, about 2 weeks after the gate incident. He was 63, retired schoolteacher, had lived in the community since the original subdivision opened. I recognized him from years of passing waves on the road. He was holding a small paper bag from the gas station bakery and a USB drive. He set the USB drive on my kitchen table first, then put the bag down beside it. I've been recording the board meetings for 2 years, he said. Everyone. On my phone. I thought someone should. Frank hadn't been alone in coming. He'd coordinated with 2 other households before driving over people who'd been watching the situation build, and had decided, independently, that the time was right. The first was a young couple, early 30s, who'd been trying to sell their house for 8 months. An HOA lien on their property filed over a disputed $340 landscaping fine had flagged in every title search any prospective buyer ran. 3 separate sales had fallen through. Their real estate agent had stopped returning calls with good news. The second was Howard and Ruth Patterson. I'd been updated on their situation in fragments over the previous months. But sitting with Howard at my kitchen table was different from hearing about it secondhand. He was a careful man, the kind who chose words slowly and meant them. He told me that Karen had personally appeared at their front door 14 months ago with a representative from a towing company there to take their vehicle as collateral against the $800 lien balance. Ruth had watched from the window. Howard had stood in the doorway and told them to leave. They left. The foreclosure warning came 6 weeks later. He told me this without raising his voice. I looked at my hands on the table for a moment. "This isn't going to happen to you again," I said. I meant it as a legal statement, not a promise. I was a man with a deed and an attorney. That was the only currency that mattered in this situation, and I was starting to understand exactly how much of it I had. I gave the USB drive to Sarah that afternoon. She had her paralegal run through all of it, 14 recordings, spanning 2 years of board meetings. Most of it was procedural minutia, fine schedules, vendor contracts, parking enforcement updates, standard HOA noise. But in the third recording, 17 minutes in, Karen's voice came through clearly. The farmer won't fight back. He doesn't have the resources for litigation. By the time he finds an attorney who'll take this on, we'll have development underway, and the filing will be a fact on the ground. And in the 7th recording, responding to a question from a board member about potential legal challenges, "We have more lawyers than he has acres. This is settled." Sarah listened to both clips twice, without saying anything. A single-party consent recording law means that one person in a conversation can legally record it without telling anyone else. Frank had been a party to every meeting he recorded as a homeowner in attendance. Every clip was admissible. More than that, Karen hadn't just committed fraud by misfiling the easement. She'd confirmed on tape that she knew the transfer was legally contested and proceeded anyway. That wasn't negligence. That was willful. I wrote the word willful under fraud in the margin of my notepad. Underlined it once. While Sarah was working through the recordings, her title research team finished the waterfront chain. The finding was exactly what she'd suspected when she first went quiet on the phone 3 weeks earlier. The developer had platted 18 waterfront lots and sold them beginning in 1989, but no recorded instrument, no deed, no conveyance, no properly executed severance document had ever formally separated those lots from my grandfather's 1,948 master deed. The title companies that issued policies on those properties in the late 80s had run their searches and missed it. The gap had existed quietly for 37 years, invisible beneath layers of normal transactions. The 18 lots were still legally entangled with the original deed. A quiet title action is a lawsuit that asks a court to determine who actually owns a disputed piece of land. If we filed one and won, the court's order would settle the question permanently, and the people currently living on those 18 waterfront lots, several of whom were HOA board members, would be living on land they didn't have clean title to. We weren't ready to file yet. But we filed something else first. A lis pendens is a notice recorded with the county that says, "There is active litigation affecting the title of this property." Once it's on record, no one can sell, develop, or refinance the affected land without that litigation resolving first. It's a legal hold, a freeze. Sarah filed the lis pendens on the farmland transfer the following Monday. By Tuesday afternoon, the developer's equipment had gone quiet. The survey crew didn't come back. The stakes remained in the ground, but no new ones went in. Karen called Sarah's office 3 times that day. Sarah returned the last call and kept it brief. Sarah also sent a quiet letter certified, no press, no announcement to the title insurance companies that had issued policies on the 18 waterfront lots in the late 80s. She informed them of the pending litigation affecting the underlying 1,948 deed and suggested they begin an internal title review. She didn't explain why. She didn't need to. Title insurance companies become very attentive when someone uses the phrase underlying deed and pending litigation in the same paragraph. They began their review. They didn't tell the board members. Karen knew about the lis pendens. She was furious about it that much came through in the tone of the 3 phone calls she'd made to Sarah's office. But she thought this was still a fight about the farmland. She had no idea that the quiet title complaint was already drafted, already reviewed, waiting in a folder on Sarah's desk. She thought she was managing a setback. She was walking toward a courtroom. Karen found out about the lis pendens on a Thursday. By Friday, she'd retained a regional litigation firm, 7 attorneys, offices in 3 cities, the kind of firm that charges by the quarter hour and bills for parking. The retainer came out of the HOA reserve fund. The reserve fund came from 96 homeowners paying monthly dues. She spent other people's money to clean up her own mess. I noted that. Within a week, the HOA filed a countersuit against me. $2 million. The claims: unlawful interference with HOA property rights, filing a fraudulent lien, harassment. The complaint was 41 pages, dense and confident, the kind of document designed to look like it ends things. Sarah read all 41 pages over a weekend. They have a strategy, she told me on Monday. It's not a good one, but it's expensive. That's the point. The letter Karen sent to the community went out the same week. It described me as someone attempting to steal community land that belongs to all of us. It said the HOA was being forced to defend the neighborhood against a hostile landowner who wanted to undo 30 years of community investment. It asked homeowners to consider a voluntary contribution to an HOA legal defense fund. She collected $34,000 in 2 weeks. I thought about those 96 households writing checks, some of them the same people carrying HOA liens on their properties, frightened enough of the board to donate money to the board's legal fight against someone else. I thought about the Pattersons, who'd nearly lost their home over $800, deciding whether or not to put a check in that envelope. I didn't call anyone. I didn't send a counter letter. I added Karen's fundraising letter to the file and kept moving. The developer's legal team moved separately, the way large financial interests do when they sense exposure. They sent a formal demand: withdraw the lis pendens within 60 days, or they would pursue consequential damages for construction delays and contract interference. Their attorney's letter put the number at $4.5 million. It outlined how such a judgment could reach my personal assets, the operating equipment, the farm structures, in a worst-case scenario, the land itself. I read that letter at the kitchen table on a Tuesday evening. My grandfather had cleared this land with a team of 2 men and a used tractor. My father had planted his first crop here, at 19 years old. The idea that a developer's attorney could attach a number to it and call it exposure was the kind of thing that should have made me want to put my fist through the wall. Instead, I poured a second cup of coffee, called Sarah, and read her the relevant paragraphs. "They're trying to make the math too expensive for you to continue," she said. "It's a standard pressure play. It only works if you don't have a stronger position than they do." "Do I?" "We file the quiet title complaint, and their $4.5 million becomes the least of their problems," she said. "Keep building." I kept building. Then they went after the bank. Someone connected to Karen's board contacted my agricultural lender, the institution that held the operating line of credit I used to finance each season's inputs. They sent a letter suggesting that my property title claims were fraudulent and that the bank should conduct a review of my loan status given the outstanding litigation. The bank sent me a certified letter requesting documentation of my current legal standing and property title status within 30 days. I want to be precise about what that was. It wasn't a coincidence. An operating line of credit is the financial oxygen of a working farm. If a lender freezes or recalls a line mid-season, you can't buy seed. You can't pay labor. You miss the planting window, and you lose the year. Karen couldn't beat me in court. so she tried to make me bleed out before we got there. Sarah flagged it in her notes as potential tortious interference, using improper means to damage someone's business relationships. She added it to the growing inventory. I gathered the documentation the bank requested. I hand-delivered it with a cover letter from Sarah's office. The review concluded without action. But I kept the bank's letter. I kept everything. 2 weeks after the Pattersons and Frank DeLuca had been seen arriving at my farm, new violation notices appeared in their mailboxes. Howard and Ruth Patterson. $5,000 for unauthorized tree trimming on their property. No warning. No prior notice of violation. No photograph of the tree in question attached to the citation, just a number and a deadline. Frank DeLuca. $3,200 for exterior lighting code violations. His porch light. He'd had the same fixture since 2009. I called them both. They were unsurprised, resigned almost. The kind of resignation that comes from being conditioned to expect punishment for stepping out of line. Save everything, I told them. Every notice, every envelope, every date stamp, don't pay anything. The retaliation notices went into a separate folder. Sarah labeled it Retaliatory Enforcement Pattern Evidence. Those 2 notices would eventually matter more than Karen realized. By the end of that week, Sarah's team had completed the full quiet title complaint. 18 properties named. 6 board members listed as defendants in their capacity as the decision-making body behind the fraudulent transfer. The legal description precise. The title chain documented back to 1948. The gap in the waterfront conveyance laid out in 12 numbered paragraphs that left no interpretive room. The complaint was ready to file. We were waiting for the right moment, a public setting where Karen couldn't manage the information, couldn't spin it before the room processed it, couldn't call a private meeting and get ahead of the story. She gave us exactly that without knowing it. Karen scheduled a community meeting. She invited a reporter from the local weekly. She told the community it would be an opportunity to hear directly from the board about the ongoing situation with the hostile landowner. She expected to use the meeting to finish dismantling my credibility in front of the people she needed on her side. The night before the meeting, her litigation attorney sent Sarah a certified letter. The demand was simple. Withdraw the lis pendens within 48 hours, or they would refer the filing to the county prosecutor as a fraudulent lien, a criminal matter. Sarah read it, set it on her desk, and looked at me over the top of her glasses. Perfect, she said. Let them make that argument in front of a judge. She picked up her pen. We file Monday. The community center held about 100 people if you packed the folding chairs close. Karen had packed them close. I counted 83 homeowners by the time the meeting started, more than had attended any board meeting in the past 2 years. Which told me something about how the letter had been written. People came because they were worried, not because they were curious. There's a difference, and you can see it in how people sit. Karen had a podium, a projector screen, a laptop with a presentation already loaded. Her litigation attorney, a trim man in a charcoal suit, whose name I later learned was Gerald Marsh, sat in the front right corner with a leather folder open on his lap. 2 board members flanked Karen at the table behind the podium. A reporter from the local weekly sat off to the left with a notebook, pen already moving. She had built a room. She had filled it. She had a lawyer, a screen, and an audience that had already paid $34,000 into her defense fund. For 20 minutes, she was winning. The presentation was well made. I'll give her that. She opened with a map, the subdivision laid over the county grid, the farmland highlighted in a pale green that made it look like it had always been community space. She walked through a timeline that began in 1987, described the easement in language that was technically accurate in every place that didn't matter and carefully silent in every place that did. The word temporary didn't appear once. She showed the park renderings, trees, a trail with benches at intervals, a picnic area near the waterfront. The kind of thing that makes people think about summer afternoons. She talked about community investment, about the board's commitment to improving property values, about protecting what belonged to all of them. A board member named Vic raised his hand from the floor planted there, clearly rehearsed, and asked how the HOA had managed to secure such a significant community asset. Karen smiled and said it had required vision and persistence and a willingness to do the difficult work of protecting the community. 3 people applauded. A few others joined. It was careful applause, the kind that keeps the peace, but it was applause. Gerald Marsh was taking notes. The reporter was taking notes. Karen was at the podium with $70 per square foot of confidence, and nothing yet to shake it. I was in the back row. I had not said a word. She noticed me about 25 minutes in. The shift in her expression was small but visible, a tightening at the corners that she controlled within a second or two. "I want to remind everyone that this is an HOA community meeting," she said, addressing the room but looking in my direction. "Non-members don't have floor rights at HOA business meetings. I'd ask anyone who isn't a community homeowner to respect that boundary." I waited a moment. "I hold title to property that is the subject of this meeting," I said. "I have a legal right to be present." A few people turned to look at me. Karen's jaw tightened again, then released. "We'll move on," she said. She moved on. Frank DeLuca stood up 6 minutes later. He didn't ask for the floor. He stood, and because he was Frank, 63 years old, known by most of the room, the kind of person whose presence carries its own quiet authority, Karen didn't immediately cut him off. He was holding 2 printed pages. "I have some questions about the timeline you've presented," he said, evenly. "Specifically about whether the board understood that the 1,987 document being cited was a temporary construction easement, not a deed." "Karen, that question has been addressed in the county filing." Frank read aloud. His voice was steady, unhurried. The words were Karen's own, from the third recording, 17 minutes in. "The farmer won't fight back. He doesn't have the resources for litigation. By the time he finds an attorney who'll take this on, we'll have development underway and the filing will be a fact on the ground." The room went quiet in the particular way that rooms go quiet when something true has been said. "That's been taken out of context," Karen said. Her voice was even. She was good at this. Those were internal planning discussions. "I have the audio," Frank said. "If you'd like to provide context for the room, I'm happy to play it." Karen looked at Gerald Marsh. Gerald Marsh was looking at Frank. Sarah stood up next. She was dressed the way she always dressed for formal occasions, simply, precisely, without anything to signal that she was about to do something that would change the evening. She walked to the front of the room with a document packet bound with a rubber band and set it on the table in front of Gerald Marsh. He looked at it. Then he picked it up. "My name is Sarah Chen," she said to the room. "I'm the attorney representing the plaintiff in a quiet title action being filed in county court. I'm formally serving notice to the HOA's counsel." She turned to face the room fully. "We are filing for quiet title to 18 waterfront properties in this subdivision. All owners of those properties should seek independent legal counsel immediately." She said it the way lawyers say things they've said many times before, clearly, without drama, without interpretation. Just the words and their weight. Gerald Marsh was reading. His expression changed somewhere in the second page. It was a small change, the kind a careful man makes when he sees something he needs time to process, but in a quiet room, it was visible. "Karen, this is a harassment tactic. It has no legal merit whatsoever." Loud, clear. She wanted the room to hear it, but Gerald Marsh was not looking at her. The reporter raised his hand. "Miss Holloway, can you show the room the underlying deed that gave the HOA authority to transfer private farmland? The original document?" "Karen, that's a matter that will be addressed through proper legal channels." The reporter wrote something down. Then, "Was the full board present when the vote was taken on the farmland acquisition?" "Karen, all required procedures were followed." "Frank, the meeting minutes from that session show 4 board members present. Your own bylaws require 5 for a quorum on property matters." A different quality of silence this time. Longer. Gerald Marsh closed the document packet and set it carefully on the table in front of him, aligned with the edge. He did not reopen it. He had the expression of a man who had been given information that had changed the nature of the work he was doing and was deciding, privately, what to do about it. A board member named Diane had been seated 2 chairs to Karen's left. She stood up quietly, no announcement, no expression, and walked to the back of the room. She took out her phone. She made a call that lasted just under 2 minutes, standing near the emergency exit with her back to the room. Then she came back. She didn't sit next to Karen. She sat alone, 3 rows back, on the far side of the aisle. She set her phone face down on her knee. She did not look at the podium again. Her face was completely white. The courtroom was smaller than I expected. County Civil Court. Wood paneling that had darkened over the decades. Fluorescent lighting that made everyone look slightly tired. 3 rows of gallery seating behind the bar. The quiet title hearing had been scheduled for a Tuesday morning at 9. Karen's litigation team arrived with 2 rolling carts of documents. Gerald Marsh led them composed, professional. the kind of attorney who fills a room with competence without filling it with noise. Karen sat at the defense table in a charcoal blazer, her posture exact. She had not looked at me when she came in. Diane was not there. 6 of the 18 waterfront lot owners had hired separate attorneys and were seated in the gallery behind their own counsel. The developer's lawyer sat on the far end, apart from everyone, a man who had not yet decided whose problem this was going to be. The reporter from the local weekly was in the last row. He had a fresh notebook. Sarah set the 1948 deed on the plaintiff's table first, not as theater. She placed it there because it was the foundation of everything that came after. And she wanted the judge to see it before she said a single word. 12 pages on aged paper, the grantor-grantee language of a different era, my grandfather's careful signature on the last page. Then she opened her laptop and projected the overlay onto the courtroom screen. The 1948 legal description on the left, the current subdivision plat on the right, and then, side by side, the 2 merged coordinates aligned, boundary lines matched, the full property description laid over the modern map like a transparency. The 1948 deed covered the farmland, and then it kept going. Past the upland, past the development boundary, all the way down to the waterfront strip, the full quarter-mile, the 18 lots. Every parcel where a board member had built a mansion was sitting inside the boundary of my grandfather's deed. No exclusion, no severance, no line that said this was conveyed away. Sarah said it in one sentence. Your Honor, the 1948 master deed has never been properly severed. The waterfront strip, all 18 lots, remains legally entangled with the plaintiff's original title. She sat down. Gerald Marsh stood. His counter-argument was the 1987 easement. He presented it as the operative conveyance, the document that had transferred rights to the developer, which had then been passed through to the subdivision and its homeowners. He placed a certified copy in front of the judge and walked through its history with the careful confidence of a man who had prepared thoroughly. The judge picked it up. The room waited. 30 seconds. 40. The judge read. Turn to page 2. Read again. Set the document down. Counsel. Gerald Marsh. Your Honor, this document is labeled Temporary Construction Easement. The judge's voice was even not angry, not theatrical, just precise. The 3rd paragraph states, and I'm reading verbatim, this easement is granted for construction purposes only, and shall expire upon completion of the subdivision project. A pause. How did this become a deed transfer of 2,200 acres? Gerald Marsh. Your Honor, the intent of the parties at the time of signing. Intent is not a deed, Mr. Marsh. The judge set the document down. Motion to void the farmland transfer is granted. Karen's hand, resting on the table in front of her, went completely still. The supporting receipts came in sequence. Each one closed a door. The county recorder's office representative confirmed that the 1987 filing had been accepted as submitted. The intake process hadn't pulled the original document for classification review. The mislabeling had gone undetected at the counter. The original document directly contradicted the transfer claim. The filing was formally voided and flagged for correction in the county's digital records. Karen whispered something to the attorney beside her. He did not respond. Frank's audio recording played next. Not the full 2 years, just the 2 clips. Karen's voice came through the courtroom speakers with the particular clarity of a phone recording in a quiet room. The farmer won't fight back. He doesn't have the resources. And then, we have more lawyers than he has acres. This is settled. The judge made a note without looking up. Somewhere behind me in the gallery, I heard a chair shift. The HOA meeting minutes went in next. 4 board members present at the vote. Karen's own bylaws required 5 for a quorum on property matters. The authorization vote had not been valid under the HOA's governing documents on the day it was taken. Karen's attorney had signed off on a transfer that Karen's own board hadn't legally approved. Gerald Marsh was very still. The last receipt was the title insurance company's internal memo from 1988, 2 paragraphs, written by a company underwriter, flagging the waterfront strip as having unresolved title history, requiring further chain examination. The company had issued the policies anyway. Their attorney was in the gallery. He had arrived with a briefcase and left it unopened on the seat beside him. The judge looked up from the memo. Based on the evidence presented, this court grants quiet title on the waterfront strip to the plaintiff's estate, 18 lots. The court's order will be recorded with the county within 10 days. He set his pen down. The court is also directing the clerk to forward this complete record to the county district attorney's office for review of the 1,987 instrument filing and the subsequent transfer notice filed 3 years ago. The last sentence landed differently than the rest. A criminal referral is not a conviction. It's a door being opened. But in a small county courtroom on a Tuesday morning, it sounded exactly like what it was. A judge looking at what Karen had done and deciding that a different set of authorities needed to look at it too. Karen, this can't be right. Her attorney put a hand on her arm. She said it again, quieter. This can't be right. I heard in those 4 words the same certainty she'd carried to my gate that morning, with the orange stamped document raised like a stop sign. This is HOA property now. The same register, the same absolute confidence, just pointed in a different direction. Diane in the gallery had already opened her phone. She was typing something. She did not look up. The developer's attorney stood, requested a brief recess to confer with his clients, and walked out of the courtroom at a pace that was slightly faster than was dignified. He did not come back before the session concluded. The reporter's pen had not stopped moving. Gerald Marsh closed the cover of his leather folder, set it flat on the table, and aligned it carefully with the edge, the same gesture I'd seen him make at the community meeting 6 weeks earlier. When a careful man starts straightening things on a flat surface, he is buying himself time he doesn't have. He turned to Karen and said something I couldn't hear. She shook her head once. He said it again. Before I left the courtroom, Sarah picked up the cut chain from the plaintiff's table. She'd logged it as Exhibit A at the start of the hearing. The first physical act of trespass on the property, documented by photograph, GPS stamped at the gate on the morning of the survey crew. A cut chain with a clean shear through the shackle. The same chain I'd picked up off my grandfather's dirt 8 weeks earlier, while Margaret Holloway told me I was trespassing on land my family had held since 1948. Sarah handed it back to me in the corridor outside the courtroom. It was heavier than I remembered. The quiet title order was recorded with the county 9 days after the hearing. I drove to the recorder's office myself to pick up the certified copy. The clerk handed it across the counter in a manila envelope without ceremony, the way county offices handle everything, which is to say, correctly. I signed for it, put it under my arm, and drove back to the farm. The survey stakes were still in the ground. I pulled them that afternoon. It took about 40 minutes. I stacked them by the gate and left them there for a week, in case anyone wanted them back. Nobody came. Sarah sent formal notice to all 18 waterfront lot owners within 2 weeks of the order. The legal situation was straightforward, if uncomfortable. They held title to land that a court had determined was encumbered by my grandfather's 1948 deed. The quiet title order didn't evict them. It established that clean title ran through my estate, and that any resolution would require either a negotiated settlement or further legal proceedings. 12 of the 18 were people who had bought their homes in good faith. They'd paid market price, obtained mortgages, raised families, planted gardens. They hadn't known about the title gap any more than the buyers in 1989 had known. Their title insurance policies, the same policies issued by the same companies that had flagged the waterfront strip as having unresolved title history in their 1988 internal memo and proceeded anyway, were now active. Claims. The insurance companies settled. They had limited options and less appetite for a public trial about a memo they'd written and ignored. The settlements covered fair market value payments to my estate for clear title on those 12 lots. The total, across all 12, came to just over $9 million. The money went into an account Sarah opened specifically for it. We didn't touch it for 30 days while the paperwork finalized. The other 6 lots belonged to board members. Karen's policy was denied on grounds of her direct involvement in the fraudulent transfer that had triggered the title dispute. Her insurer's denial letter was 4 pages and precise. Without insurance coverage and facing a court-ordered title resolution, her attorneys negotiated a sale of the property to satisfy the judgment. She vacated the house on a Wednesday morning. A neighbor told me later that she'd left before most of the street was awake. No moving truck, just a car, packed, gone. The 6 board member settlements added another $3 million. Total, approximately $12 million. I'm not going to pretend that number didn't land with weight. It did. But I want to be accurate about what it represented. It was the value of title that had always been in the deed. It wasn't a windfall. It was a correction. The DA's office opened a fraud investigation within 60 days of receiving the court's referral. Karen was ultimately charged with filing a fraudulent property instrument, a misdemeanor under the state code, the applicable charge for deliberately mislabeling a legal document when filed with a county recorder. Her real estate attorney, the one who had prepared and submitted the 1,987 easement as a deed transfer, was referred to the state bar for disciplinary review. I don't know the outcome of that review. It wasn't my proceeding to follow. Gerald Marsh withdrew from the case 2 weeks after the hearing. His firm sent a letter to the HOA board indicating they were no longer in a position to continue the representation. The HOA's countersuit against me, the 41-page complaint filed with the regional litigation firm, the $2 million harassment claim, was voluntarily dismissed. The developer forfeited their contract deposit and walked away from the farmland acquisition. Their staging equipment had been sitting idle since the lis pendens was filed. They never set another stake. The community held a special election for the board 6 weeks after the hearing. 91 of 96 homeowners cast ballots. Frank DeLuca was elected president by a margin that didn't require a recount. The new board's first official actions: void all retaliatory fines issued in the 14 months prior to the election, including Howard Patterson's $5,000 tree trimming citation and Frank's exterior lighting violations. Reverse the Pattersons' original $800 lien with a written apology from the board. Return the $34,000 collected in Karen's legal defense fund to the donors who had contributed. That last action took some administrative work. It was done. Frank called to tell me when the Pattersons' lien reversal was recorded. He didn't editorialize. He just said it was done, and that Howard had asked him to pass along that he appreciated it. I said to tell Howard I was glad. I attended one meeting under the new board. They invited me, not required, not expected, just a conversation about what a reasonable ongoing relationship between the farm and the community might look like. We agreed on terms for a small agricultural easement, a corner section of the property, fenced and accessible, where the community could establish a garden. The agreement was generous, and it was entirely on terms I was comfortable with. It was written, notarized, and filed with the county the following week. The difference between that document and the one Karen had filed 3 years earlier was 11 pages and a complete absence of fraud. A few weeks later, a handwritten letter arrived from Howard and Ruth Patterson. I read it once. I won't repeat what it said. It wasn't written for anyone but me. I folded it along its original creases and put it in the barn with my grandfather's papers, in the same wooden box where the original 1,948 deed had been kept for 75 years. It fit there naturally. My grandfather had placed a survey marker at the true corner of the original property when he bought it in 1948. A plain iron post, stamped with a parcel number, set 18 inches into the ground at the northwest boundary. It had been there through every season since, through the subdivision, the HOA, the development rights sale, Karen's crew, all of it. Karen's survey team had driven their stakes 20 feet short of it. They'd missed it entirely. It was never moved. It never needed to be. It had been marking the same line for 75 years, patient and indifferent, waiting for someone to look at it correctly. I walked out to it one morning and stood there for a while, just to see it. The first full harvest on the restored farmland was on a Tuesday in late October. I ran the combine down the south field before sunrise. Same rows my father had run, same rows his father had cleared before him. The soil turned the way. Good soil turns heavy and dark, giving way evenly. No survey crew. No equipment I didn't recognize. No orange-stamped notices. Just the work, the machinery, and the particular silence of a field at dawn. It was an ordinary Tuesday. That's the only way I know how to describe what had been given back. That evening I went to the gate and hung a new chain. New lock, new hardware, the right gauge for the post. I threaded it through and snapped it closed. Then I picked up the old chain, the one Karen's crew had cut that first morning, the one I'd carried into Sarah's meeting and through a county courtroom as Exhibit A, and I took it into the barn. I found a clear section of wall between the workbench and the window. I drove 2 nails, hung the chain between them, and pinned the certified copy of the quiet title order directly below it. 2 things on the same wall, one from 1,948, one from this year. Same land, same deed, same family. The chain of title had never been broken. It had only been tested. I turned off the barn light and went inside.